Good morning. Due to democratic process of elections to lure the voters, freebies are announced that resulting every state government to borrow huge amount of debt, and therefore to maintain the balance between union government and state governments, and to have a check over state government's borrowing power, the Union of India seems to have passed an act. So the state of Kerala filed a suit. AR 2024 Supreme Court 2649, AR 2024 Supreme Court 2649. State of Kerala versus Union of India. Therein they filed a suit, and they also filed injunctions to allow the state government to borrow as earlier existing prior to the Amendment Act 13 of 2018. So that's Section 4 of Fiscal Responsibility and Budget Management Act 2003 was amended to ensure that aggregate debt of central government, the state government, does not exceed 60% of the gross domestic product by the end of financial year. So this is what, the advocates who are interested in politics, advocates who are pursuing particularly postgraduate research students must go through the judgment, and for young lawyers there is one ratio was given about mandatory injunction and prohibitory injunction. That is for young lawyers, and you may also read the at least index of the judgment. The plaintiff Kerala state government challenged 293 of Constitution, which dealt with the borrowing powers, and Article 131, 145 about the power of Supreme Court to interfere with. So finally they said it should be decided by 5 benches. Therefore, those issues were referred to full bench, and the full bench has to be constituted. I do not know when it will be constituted. But so for young lawyers, Order 13, Rule 1 and 2, they say for grant of injunction, Order 39, under Specific Relief Act, triple test should be effectively applied. Number 1, prima facie case. Number 2, balance of convenience. Number 3, irreparable injury. Here they say what it was mandatory injunction. They say you directing them to do one thing. Prohibitory injunction directing them not to do anything. This is what. That was writ of mandamus. Mandamus also, the case under Article 226, the court can direct to do or direct not to do when they are not legally bound to not to do. When they are legally bound to do, if they are not obliging that legal command, then they can issue writ of mandamus. This is what. So go through the judgment, very interesting. If you are really interested in politics, you may be aspiring for finance minister, and you may want to be an advocate, additional advocate general. All these things will be helpful for you. Best wishes. And sorry to say that a lot of advocates indulging in plotting murder, transferring money to accused. Very sad state of affairs. I can't say more than that. It's only preliminary stage of inquiry. Best wishes.